Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm. Offices conveniently located Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, Gastonia, and now in Morehead City. They are practicing attorneys here in North Carolina and, as aforementioned, managing partners at the firm. And on the program today, Cassandra Nicholas remoting in from Morehead City's office, and we have Taylor Scruggs-Smith, also an attorney at Whitaker and Hamer, joining us in studio. I'm Morgan Patrick, consumer advocate, and away we go.
I think this is a good time to remind everybody that the attorneys on the show here are licensed to practice in North Carolina. We know North Carolina law as well as we can, but we comment on a lot of things that maybe don't have to do with North Carolina law, have to do with federal law. We talked about a California criminal case earlier. And of course, we're not licensed to practice in California. But we do inject our opinions to some of these topics. And as we've discussed, the Supreme Court, the U.S. Supreme Court, is back in session. They have a slate of cases that they're going to be hearing oral arguments on for the next couple of months. And a lot of them are going to be very fascinating because for the first time in a long time, I don't like to talk about the Supreme Court as, Republican versus Democrat. I don't like to make it politically charged. That's not the way we're trained to look at the Supreme Court as attorneys. They're justices, and some of them have a liberal slant, and some of them have a conservative slant, just like in the general public. But they are professionals. They're justices. They're trained to look at the facts and the issues, and kind of reconcile that with their own the law with their own personal beliefs. But as is well reported, we have a conservative slant on the Supreme Court. For last year was the first year. This is the second year. We've got a new justice. So watching the Supreme Court in action is very fascinating. If you ever have time to do it, the oral arguments, they're easy to find. They're not televised. It's not cameras don't really go in federal courts, but you can listen to the oral arguments, and they're always very fascinating. And kind of a local connection here. So this week, oral arguments were heard on a case brought against the University of North Carolina. There's also a similar case brought against Harvard. So University of North Carolina and Harvard about the use of affirmative action in their admissions process. And so this has been before the Supreme Court several times when the Supreme Court had a more liberal slant. And so this is getting a lot of attention because I think this has been common practice at most universities pursuant to the prior cases. And for the oral arguments, where did they go? Cassandra, did you follow those?
So not very closely. I was very busy working.
That's right.
But our new justice, Ketanji Brown Jackson, was sitting out from the Harvard oral arguments because she was on their board up until really recently. But she was on the UNC case oral arguments and got in some good arguments about what she believes is the need to continue using affirmative action as one tool to create a diverse student body. The conservative justices argued that this is really still following precedent to discontinue using affirmative action because the previous case, being 19 years ago, it specifically laid out that using affirmative action and using race as a criteria for admission to college was necessary at that time, but needed to be time limited. So we'll see if we are at that time now.
I find it interesting because affirmative action was, of course, brought up to help get African Americans and other minorities into colleges that usually would have not allowed them because they weren't legacy students or they didn't have the big money that other people had. So it was a way to force a diverse student body in upper education, like universities.
And those factors are still at play, that legacies still get extra points towards admission, money, donations those are still considered and make a difference. So I don't know how that plays into this argument.
I wonder how it plays into the argument in terms of standardized testing, because you still have to put your race on standardized testing, even in schools. So how it, even especially in lower schools and high schools, even for the LSAT, which we all bravely sat through in that horrible exam that it is. But even that still considers your race. You have to always mark it. So I think I see some of the justices' argument of like, this is just another factor that we always account for. Why, like, this should obviously continue because all these other factors continue. It's not the sole reason, I think, was the arguments being presented by people for University of North Carolina and Harvard, that it wasn't the sole consideration, wasn't race.
Right, because the prior case law is, well, there was no quota system, right? You can't say I'm going to admit this many of this race, this many of this race. So quotas, the court have already thrown out quotas, but right, it can be used as a tool, just like legacies. The questions on the legacies, those are very interesting because a lot of the justices jumped on that. Well, you're giving this preferential treatment to legacies from a time when some races wouldn't have gotten into Harvard, let's say, right? And so if you're 40% of your class or whatever it was is a legacy, then that's not going to be a very racially diverse class. So that was interesting. I want to note here, when we were growing up, we took the CAT test. Do you remember that? Is that what y'all had to do? Did y'all take the CAT test when you were in elementary school? Did that ever happen?
Like you meowed at people? I don't understand.
It was like a standardized test. And you took it at the end of the year. They called it the CAT test. It was the California Achievement Test.
No.
I don't think so. I don't think
Not
that's a
us.
thing, man.
Well,
Maybe in the 40s.
We were in elementary school.
Is this a cat? Is this a dog?
Morgan, did you take,
It's an easy test. I
Yes.
aced it.
I took it.
Yeah.
Yeah. So anyway, you took that test, a standardized test that you had to take back in the 80s and earlier, I guess. But it always asked for your race back then, and we were just kids. We always, there was like a Alaskan something option, and so we all went in for that.
These Alaskan kids are really killing it.
They're moving it down. They're moving down to Raleigh and really lighting us up.
In Maryland, which is where I grew up, we still had standardized testing. I think ours was generally in April, but still always ask for your race. And I think nowadays they have the option of, if you're more than one, fill in 2 bubbles. More often now you see that.
Wow.
So a lot of people will, if they know they're mixed, they will fill in the bubbles.
Do they have just other? I mean,
yeah, they just have other. Because when I remember when I was in elementary, it was, you couldn't pick 2, you had to pick 1, and I always put other. So they still ask that, like, you have to put your race on everything. So I think it's.
I ain't taken a standardized test in a while.
No, you. There's nothing you could do to make me take one right now.
Yeah,
Tell me the fate of the world depends on it. And we're just going down, man. That's it.
I think you still have to do it for the SAT, the ACT, and LSAT.
One of the we talk about this, the Supreme Court case. This Supreme Court case was brought by a nonprofit organization that is against the use of affirmative action. So, we talk about this a lot. A lot of these Supreme Court cases are either made by a nonprofit organization that's motivated to change the law, and they make it on their own if they have standing, or they go find defendants who have been affected and kind of sponsor the legal representation of that defendants. I think it's always very fascinating to figure out how this got before the Supreme Court to begin with. These were filed back in 2014. There was a lot of, we talked about amicus briefs, friends of the court filing. There's a lot of people who are interested in this. So there was like 100 or some crazy number of amicus briefs where other institutions who would be affected kind of chimed in with their opinion. And, again, tons of oral arguments. Every justice was asking questions. Every justice was engaged. But I think part of this too was, I saw part of this argument was that Asian Americans, in this system, it sounded like Harvard maybe was penalizing Asian Americans in the process a little bit. So it was weird. There was a lot of talk about, okay, you can use race, as part of affirmative action. You can use race as a factor, just like you could use a legacy as a factor, just like you could use these other things as a factor. But I also saw UNC had like 46. I can't remember what the numbers were. It was like 46,000 applicants last year, and they accepted like 4,200.
Yeah.
Which is just crazy to me.
I mean, college is not as easy to get into.
Back in my day,
They just looked at your CAT test score.
I just applied to a couple. We want
to get the best Alaskan CAT test performers.
So
back in my day, you took your SAT. You hoped you did well, and you paid the whatever it was, the fee. I think I had to write an essay. I don't know, man. It's
So
different.
also not law, but college application fees are high too. So there's a lot of programs in high schools that try to help because it's hard enough to pay the fees to apply and then pay because schools charge you now to send your official transcripts and things like that. So one application, I can't remember what school it was, but I know one of my college applications was just the application was like $85. And then it's like another 20 or 30 for the school to send official records.
I don't care how smart you are. If you're 18, if you're 17, 18, you're dumb, right? I don't care. Like, I'm talking about myself,
You
right?
take nothing from this show.
You're world dumb. You don't know anything.
Unless you listen to this show.
You're not dumb. You're world dumb.
You might ace AP chemistry and AP biology. You might have a 4-point or 5-point, whatever it is now, right? You might be but yeah, I'm just amazed I figured out how to get into college.
Yeah.
That's no bearing on my legal acumen now.
What is grade point up to now? Is it like 8 point something?
It depends on what program you're in. So if you're a regular school, it's typically still 4.0. But for instance, I did International Baccalaureate program, which is a 5.0 scale. Starts in ninth grade.
So we're talking like 5 point something.
I saw some cross country runner
Yeah.
that was 5.2 or something. I was like, I got no shot.
They gave him extra points for being able to run long distances.
And so he like won some award
That's
for cross country, and
incredible.
they mentioned his GPA, and I was like, well, if that's what it takes, man.
Yeah.
Did you start running right away?
I rarely run.
I want to do a show with you just running the whole time, man. And just,
We can bring in a treadmill. We can do that.
That'd be fantastic.
That'd be terrible.
All right.
I thought it was interesting, though, how they tried to talk about race neutral options, like not bringing it up at all. And I think there's been arguments for that for even job applications to like just take race off and just look at who the person is that's applying.
Really
Yeah.
smart. When you hear go ahead, Cassandra. Sorry, I'm talking over you.
Clarence Thomas had an interesting line of questioning. He was on the court already for the original decisions 19 years ago and was not yet speaking out loud in oral arguments, but he is now. But he was asking each attorney, what is the educational benefit of even having diversity in schools? And hearing that question from a Supreme Court justice was jarring.
I'm telling you, I know we're coming up against a break, but these were arguments. I like to hear these justices because what they do is they have these attorneys up here arguing for either side. And they give them all these hypotheticals, and these attorneys are trying to really attorney it up, like avoid answering anything they don't want to have to answer. And you're in front of the Supreme Court, and the Supreme Court just hits you with these questions, these hypotheticals. It's just interesting to hear their thought process. But we won't get a decision on this for a while. But
Hopefully this one won't get leaked.
yeah, hopefully this one won't get leaked. But anyway, it was very fascinating.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm. Again, the power behind the program, and we do believe at least a 4.0 grade point average for the show. Offices located Raleigh, Garner, Clayton, Goldsboro, Fuquay, Farina, Gastonia, and Morehead City. They are managing partners here. We're talking about Josh and Joe, and they're practicing attorneys here in the state of North Carolina, as are Cassandra Nicholas, who's joining us remotely from Morehead City, Taylor Scruggs-Smith in studio with us today. If you've got a legal situation you're facing and you've got questions, got a phone number for you, 800-659-1186. That's 800-659-1186. Leave your contact info, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the show. Questions@theoutlawlawyer.com. We're back to wrap it up right after this.